I welcome you to another exciting episode of Law and You. And for weeks now, we treated issues about inheritance rights, and we also were able to interact with the bickerings that may occur when a man or the head of the family dies intestate. And for us not to have those bickerings or litigations, which is costly, and for us to save money, instead of going on that path, there is need for estate planning. And today we'll be looking at succession in estate planning. I still have my erudite, dependable ally with me, a barrister, a legal practitioner, and he is Akigbe Oseogo. Thanks for joining me.
Thank you for having me. Good afternoon, Mr. Philip.
All right, now we've been treating this issue concerning inheritance rights, and for us not to have bickerings, like I said earlier, what do you see as estate planning, in order to save the cost or the chaos of a man or a head of family dying intestate?
Okay, so when we talk about estate planning, we are talking about a process of transition from one generation to another. So succession basically is transition. You could also call it intergenerational wealth transfer. So a man acquires assets and then he makes a conscious plan towards transferring that asset or that wealth or that valuable to another person. Now, if you notice, there are certain brands that were created long time ago, and they are still in existence. Some of those brands, you even wonder why they have to advertise their products, because those products are now household names. The reason why they have existed for such a long time, hundreds of years, is because they created a well-structured plan.
Okay.
Yeah, they created a well-structured plan. So there is a deliberate plan towards when A is there, he's going to hand over the baton to B, and then to C, and then to D. It's structured. It's the same thing with estate planning. Now, so what we find today is that people are only interested in the acquisition of assets. They are not worried about what will happen to these assets when the inevitable occurs. So much as you are going to make a lot of effort to acquire assets, you ought to also make that kind of effort in planning for what will happen when the inevitable occurs. Now, one of those ways of planning for the inevitable is by writing a will. In fact, a will is the most traditional, is the, how do I put it now, is what everybody knows.
It's common.
It's common
to everyone.
Yes. So one of those traditional modes of disposition of assets is through a will. What is a will? A will is a document in writing by a testator or a testatrix. Now, a testator being a man, a testatrix a woman, right? In that document, he expresses his intentions of how his assets should be distributed upon his demise. And then he appoints two individuals, at least two individuals, called executors, to carry out those wishes when the inevitable occurs. Under the wills law, that document ought to be in writing. It ought to be signed by at least two witnesses. It identifies the asset and identifies the beneficiaries. And then, but that document only comes into force upon the demise of the deceased. So even if he writes that will, that will begins to speak when the inevitable occurs. But you see, anybody can write a will. The testator or testatrix can even write the will himself.
Okay.
But the only challenge is that there are certain requirements
legal
requirements, which he may not avert his mind to. And then if he decides to write the will himself, when the will is tested, in the court of law in a process of litigation, of course, it's going to be thrown out.
Okay.
So let me put it this way. So while anybody can write his will himself, it is advisable that you get the services of a qualified legal practitioner to advise you appropriately. Yeah. So now, the content of the will, at the time of writing the will, he must be of sound disposable mind. His intentions must be clear. So if maybe he is suffering from one form of infirmity that affects his ability to coordinate his thoughts, then it means that his intention is not carried along with that document. It will be questioned.
To be questioned.
Yes, it will be questioned. So, and then again, if he has sound disposable mind, he's been able to identify the beneficiaries, he's been able to identify the assets, and he has witnesses, that's persons who were there when he executed the will, when he signed the will, then it's good to go. Now, but why I emphasize the point that he can write his will, but he must seek advice so that he doesn't make mistakes. So, for example, in executing the will, he has to execute that will in the presence of the witnesses.
Okay.
Or he may privately execute the will and call the witnesses in each other's presence to attest to the will, to say, oh, I was here when the will was written. So you find cases like Apatira and Akanke where two witnesses, but one of them said, oh, I wasn't there when the other signed. That issue on its own will invalidate the will because
they need to be two.
They
two
need
persons,
to
at
be,
least
yes, to be sure that the man signed the document.
Okay.
And the idea is for his intentions to be carried out. Remember, the will starts speaking upon his demise, right? So once that happens, it's properly executed, it's properly written, it's properly drafted, then we have a good document.
Okay. Most times people say that for someone to go on the path of writing a will or making a plan, there must be an estate. Otherwise, if there isn't an estate, there isn't need to do that. And now, at what point in a man's life should he go on that path on writing a will? Is it at when he already has the estate, or what qualifies an estate?
Very beautiful question. So there are situations where I'll digress a bit and then come back so that I do not lose the trend. So a man writes his will before he got married. The moment he gets married, that will becomes invalidated. Except the person who he eventually gets married to was in the picture at the time he was writing the will. So if he writes a will and then there was nobody, he didn't have a wife and all that, and there was no plan of getting married to that person, the moment he gets married, that will
is invalidated.
Invalid. If he contracted a native law marriage and then eventually contracts a statutory marriage, of course the will survive because it is the same lady that he was with at the time he wrote the will under native law. So I'm only just trying to buttress the fact that you need a professional to advise you.
Yes.
So that
how
you don't
to go about it.
Yes, on how to go about it. Whatever asset you have. So
there must be presence of an asset.
Of course.
And again, when we say estate, there's this mindset of a lot of us that for us to say one has an estate, it means one has buildings, huge assets. So what can be quantified as an estate?
What you own. So there are,
even if it's a property.
Yes, there are two types of assets. You have the tangible asset, right? You have the intangible asset.
Okay.
So the tangible asset is a house. You can see it, you can touch it, you can feel it, you can walk in. There are intangible assets. We could also call them choses in action. So, for example, you have shares. In those days where shares were still very valuable, you could have shares in a company. You can't touch it.
No.
So you could also have an interest in a company. So you could have you could be a shareholder in a company. Those are assets, but you can't touch them. They're intangible.
Okay.
So you could even, I always like to use this example, your Facebook account, your Instagram account, your...
As an asset?
Yes.
As intangible assets?
Intangible assets.
How does that translate? To...
In fact, the law calls them digital assets.
Okay.
So you can transfer your interest in that your Facebook account to somebody else. So we need to explain it better by saying that those who qualify to write a will are not those, you don't have to have 10 houses or 50 houses. That's not an estate. Your estate is a sum total of the things you own.
In buildings? Or
not buildings, whether tangible
or intangible.
Or intangible. So it doesn't necessarily have to be a car, a house, shoes, ties, coats, TV set, anything. As long as you are the owner, is traceable to you, then you can transfer.
Okay, that means at the point of planning this estate,
yes,
it means that you must have these things on the ground.
Yes, they
both tangible and intangible. Not what is futuristic. That maybe in the nearest future, when you own a particular asset, you will want this asset to be given to A, B, C. Is it done that way?
Now, so if it is not in existence at that time, when it comes into existence, that provision, we can only find that in the laws in Lagos. Yeah, the wills, the administration of estates law in Lagos that incorporates assets that will come in thereafter.
Later on.
So it depends on the tenor of the law. But in the real sense, after writing the will and then you acquire assets, those assets will now constitute part of the residuary estate, not indicated in the will.
Okay.
Yeah, but it is still his own, except that those assets will now be distributed outside the will, right? But they still belong to the testator or the testatrix.
Okay, let's look at where a will can be subject to changes. If it's possible that once a will has been registered and with the presence of about 2 witnesses,
yes,
at a given time, can there be changes?
Of course.
On the will, yes, or can it be revocable?
Of course.
Okay.
When you see a will, a properly drafted will, the first line is that this is the last will and testament of Mr. John.
Oh, so there must be
will
several
and testament of Mr. John. Now, he may change his mind later on in his lifetime and write another will. The current will automatically revokes the latter.
Okay.
So a properly drafted will, for example, will say that, will make reference to that one and say that, oh, I've revoked it. But even if it doesn't, the new document automatically revokes that by operation of law. He may also decide not to revoke the entire document. He may decide to just alter certain parts of the will. That he can do through, maybe for want of a better word, a mini will called a codicil.
Okay.
Yeah, so, but once that is registered and, it shows that he properly executed it, he was of sound mind, his intentions were clear, then, it will qualify as a will.
Okay, let's look at, can I say I'm digressing this time, but let's look at deeds or gifts.
Okay.
Because I understand that some of them may not be revocable. Take, for instance, there's a document in that regard where, the testator, gives gifts or deeds to another entity or transfers it. At that point, can you say that such that is transferred can be revoked?
Okay, so if we speak of a deed of gift, we have 2 types. Is either conditional or unconditional. So if it's a conditional gift, if that condition has not been met, it is revocable. If the condition has been met
or accepted. Okay.
No, met. So I'll give an example. Mr. A says that this property will go to his daughter if she agrees to study law.
Okay.
Now, the moment she buys the form and is admitted to study law, that makes the gift complete.
Complete.
But if she chooses not to study law
and take another profession, It's incomplete.
that gift becomes revocable. In fact, by operation of law, is revoked.
Okay. Okay, so there are conditions.
There are conditions. So if
it can also be unconditional.
if it's unconditional, you can't revoke it.
Okay.
But if it's conditional, if that condition has not been met, then by operation of law, the gift is revoked.
Does that form part of a will?
Yes. So a man can decide to create a gift and affirm it in his will.
Okay.
And say that, oh, I have a certain property in Upper Sakumba and I'm giving it to my daughter. And then he creates a separate document, a gift, and gifts it out to the young lady. And in his will, affirms that property I spoke of in my deed of gift, just to solidify it.
Okay.
Yes.
Just in case you're just watching, it's Law and You, and I've been speaking with a barrister, a legal practitioner, and he is Akigbe Oseogo. No doubt this topic will also excite you to send reactions. And of course, you can pouch it as a short message on our WhatsApp line that doubles as a text line, which is writing on the screen. And back to you. Let's test the waters a little bit. There is what we call a trust.
Mm-hmm. Is
it different from a will?
Of course.
How different?
Now, so I normally would say trusts versus wills.
Okay.
That's another very broad topic on
which we may not substantially rest on today. Anyways.
No, we can't.
Okay,
but let me give you.
We can't exhaust it on this episode.
So let me give you a snippet. So,
okay.
Remember I told you that part of what the testator or testatrix will do is to appoint executors. They will carry out his wishes upon his demise, right? When that happens, when he eventually passes on, they will have to apply for letters of administration to administer the estate, right? So, coming to a trust. In a trust, the settlor, he's called a settlor. So remember, in a will, we said he is a testator or a testatrix.
Yeah.
But coming to a trust, we call him the settlor. That's the owner of the property.
Okay.
Now, the settlor appoints, in his lifetime, appoints a certain person called the trustee to take over the management of a certain property for the benefit of a beneficiary.
Okay.
So under a trust, you have the settlor, you have the trustee, and you have the beneficiary. Now, the moment he creates that arrangement, the property no longer becomes his. In the eyes of the law, the property now becomes that of the trustee. Except that the relation...
Why in his lifetime?
While in his lifetime.
Okay, so that's the difference between that
yes.
and that of a will.
So in a will, the will begins to speak upon the demise of the deceased.
Yes, of course.
A trust can start speaking even while he is alive.
Okay.
And when that happens, he no longer becomes the owner of the property. So you cannot, if you have any case against him, as it were, over that property, it will no longer be the owner of the property, the settlor. It will now be between the trustee and the person who is making a claim over that property.
Okay.
So it shields, a trust shields the settlor from...
All right. I think we'll delve into that deeply in our subsequent editions.
Yes.
Now, let's come back to the aspect of the will. And you made mention of executors.
Yes.
Are they different from witnesses?
Yes, they are different from witnesses.
By adventure, the executor dies even before the testator. Mm-hmm. And the testator never had the opportunity to get another executor before his own demise. Mm-hmm. What happens?
So that's why this issue of drafting a will is a solemn process. It's something you have to think through very carefully. So in appointing an executor, you are not going to appoint someone who is frail.
Okay.
Someone who is, a lot older.
But death can come to anyone at any time.
Of course. So,
irrespective of one's medical or health status.
Yes. So I just needed to make that point. Then the second point is there are minimum of two executors.
Minimum.
So
they can be more.
They can be more. We cannot expect that two of them would die at the same time.
Okay, if one dies, it means the other one can validate it.
If one dies, the other one has a duty to apply to the High Court. Remember, the High Court of every state performs a supervisory role over probate matters.
Oh, of course, yes, I was
so,
going there. Yeah.
so he can apply to the court to say, I'm the only one alive now. Please appoint someone else to join me in the process of execution of the will.
Oh, who appoints in that case?
The judge, the High Court.
Okay.
Yeah, so he's going to file an application, possibly recommend some names, and then the judge...
Which could be relatives to
relatives.
deceased.
Yeah, but the idea is to ensure that the wishes of the deceased are carried out.
Unbroken.
Yes, so that even in the... That's why we say that the will speaks from the grave. So even while he's resting in peace, his wishes are being carried out.
Okay.
Right? So I needed to make another point, another legal point, that so if the man if the testator or testatrix writes a will and then puts his wife as his wife or the husband, remember I said testator or testatrix,
yeah.
his spouse, okay, let me put it that way, put his spouse as an
executor?
No, well,
no, or a witness?
As a witness.
Oh, okay. Oh, but
that's dangerous.
That's very dangerous.
Yeah. What the law will do in that situation is to say that the gift you got, the benefit you derived, or the asset given to you in that will be declared void.
Wow.
Yes. So that is why I continue to emphasize that in writing a will, yes, you must think through it, but you must get professional advice.
Okay, you know, when you spoke about the danger in it, you know, having a spouse as a witness, we both laughed over that. But I don't know if the viewers will understand that. What's the danger in that?
The danger is that if his spouse is a witness and also a beneficiary, the asset the asset going to that particular person will be void.
So okay, because
but not the entire will.
Sentiments may come in,
of course,
to tailor the assets, you know, in the will, in her favor, his or her favor.
Yes.
Okay.
Yes. So you have to be careful, and then there is an age for writing a will. I think maybe I should have started with that. 18 and above.
Yeah.
So we have a lot of young chaps these days who have so many assets and they are just excited, and then if he's 16, that will is just a mere piece of paper.
Okay.
Right? So if he's 18 and above, he can write a will. A witness to that will doesn't necessarily have to be 18, because the Evidence Act allows for a minor to give evidence, but the only thing the Evidence Act, the court will want to know is whether that person is smart enough to understand what he's doing or what he's saying. So age doesn't count for witnesses.
And can we say it's also safe for the beneficiaries not to know what the will is all about until after the head of the family, you know, is gone? In order not to deliberately tamper with the document.
For his safety, yes.
Yes, of course.
Because you know the will starts speaking when he dies.
Yes, of course.
They may just decide to take his life.
Okay.
And say, so that let's speed up the process.
Thank you, Akigbe. Well, we're going to be having some reactions, no doubt, as a result of this episode. And you pouch your messages or response via the number on the line that doubles as WhatsApp, and of course text line, and we're going to be treating it in the subsequent episode. Big thanks for taking our time to be part of this.
Thank you,
Akigbe.
Thank you.
And big thanks, viewers. We'll do this again same time next week. Goodbye.